So thank you for being here. And of course, thank you to Leah for organizing this and hosting us again. We are here today to discuss about dealing with competition authorities, increasing powers and bureaucracy, and to give you an in-house perspective on this. So this panel is managed by ICLA, and for those of you who don't know it, it is the in-house Competition Lawyers Association. It's an informal association. We are a bit more than 500 lawyers, mostly based in Europe, and we use this association to usually debate common professional interest, but we are just speaking in our personal capacity always and do not represent any company, as we are doing today here too. So we will discuss today's topic with Felix Fernandez, who is litigation manager at Hewlett-Packard, and Daniel Lopez-Ruz, who is senior legal counsel of antitrust and trade at Delivery Hero. We were also supposed to have with us Natasha Franklin from British Airways to have her UK perspective on many topics, but unfortunately she couldn't make it in the end, so we will have a bit more time, perhaps. So I would start this conversation leaving the floor to Felix Fernandez. So happy to hear your views and your challenges that you're experiencing in these days.
Thank you. Appreciate the invitation and the kind introduction. I'd love to know in the audience, where are you coming from? I mean, who am I facing here? Who's a friend or a foe, so to speak? So, no, seriously, our obviously legal counsels, most of us, but in-house counsels. How many of you can you raise your hands so I can kind of get a feeling? All right, good. Anyone from any authority? Any present? Okay, which authority, if I may? Sorry, Italy. Okay, good. I'll try to pick up an Italian example for you. All right, and then obviously legal professionals, external lawyers, as we say. Okay, cool. Okay, so I was thinking, reflecting on the title, Increasing Powers and Bureaucracy. As an in-house counsel, the first thing that came to mind, and I don't know if this is something that you may share, is requests for information that we may receive, at least I may receive from time to time, whether it's in the context of a merger and acquisition, or whether it's in the context of something else. For instance, an investigation, or as a result of a raid, or as a result of a market inquiry, for instance. And thinking about bureaucracy, I always found very challenging the deadlines that the authorities set. It's like we live in different worlds. I feel there's a lack of empathy or at least maybe a lack of knowledge on the work that we perform. We have so many things to do during our days and cases and then there's this request for information and they give this 3-day deadline, which is sometimes we don't even know where to start. Obviously, we try to explain this in a very kind and very direct manner. But I always hear back it's just, we have our own internal deadlines and we have this, it's something almost beyond our control, right? Which I kind of feel like, sometimes it can be a little bit unfair for legal counsels, at least. All right, I'm giving the perspective of an in-house counsel, first of all, because sometimes there may be a lack of a staff. There's obviously holidays in different, especially if your company operates in different parts of the world. It's a mess sometimes trying to coordinate different time zones. As an American company, I'm dealing with different jurisdictions. I have a tendency to try to go to bed at some point at night and have dinner. And this is something that sometimes it's you know, I guess people don't, well, maybe forget about this or just, you know, look at with the national or European view. And this is something that I wanted to complain. I have a long list of complaints. Apologies, right? If I'm preaching to the choir. Another point that I wanted to raise is sector inquiries. They sound really good. On paper, in theory, they sound awesome. I mean, yeah, obviously you need to understand, and if there's any challenges that need to be addressed in the market, great. How it feels from an in-house perspective, it feels like a fishing expedition. It feels like stand against, you know, the wall, hands raised, and give us all your contracts, all the information. By the way, you have 15 days. Maybe it can be extended for another 5 days, and you don't even know sometimes what you're presenting. It's a great way, don't get me wrong, of understanding more the business. This died or no? Okay. It's a great way of breaching out certain gaps, of sometimes even identifying areas, for instance, in contracts, certain wording that needs a little bit, you know, more clarity. It's a great way, but it feels like it's not really, the main goal is not really about fixing a particular market. It's more of let's see if we open 3 or 4 cases as a result of this sector inquiry. That's how it feels. Also, I find it a little bit odd as an in-house counsel that let's say that there's sometimes this divergence between EU authorities and national authorities. I remember there was the there was the European Commission's e-commerce sector inquiry back in, was it 2014, around, yeah, more or less, 2015. And there was, I think it was like maybe 2-3 years, or it felt like 2-3 years, maybe it was more. In Greece, there was another sector inquiry into e-commerce, which, you know, it's a little bit odd, right? It feels like, again, it's not really about authorities discussing and trying to address market issues, but more of a, let's see if after this 3 or 4 cases justifies the effort and the resources. Because at the end of the day, you know, national authorities and European authorities, you know, they're human organizations with budgets, and they need to show results. I think it's important also to understand that the difference in practice when it comes to the different authorities. You know, you have these inquiries, these requests for information, these investigations open, but when do they really end? So if you know, if after 2, 3 years, 4 years, you don't hear back from the authority, is the case closed? Is it really? I found I have 2 set of questions or 2 possible answers to that. It depends on the country. I've seen authorities that they have not taken any action whatsoever. You don't hear back from them for 5 years, and then 5 years later, they say, "Hey, hello, you remember me?" So I have another request for information for that case, and it kind of makes you wonder whether there should be some sort of time limit, you know. Especially since I think it's only fair if we in-house counsels are suffering the deadlines from the authorities. I think it's fair that you guys suffer too the deadlines. Especially, you know, after 5, 6 years, it doesn't justify. I understand maybe 18 months is a little bit a short time frame, especially if the investigation is complex, involves, you know, I understand that. But 5, 6 years, I think that's you know, tampering or stepping into procedural breach of rights, probably. Again, it's something that I've seen, for instance, I need to, here on this point, I need to commend the Portuguese Competition Law Authority. In my experience, it is the only authority I've dealt with that they were kind enough through 2 years to send a letter and say, thank you very much for all the information. You know what? We're not going to take anything. We're going to close this. And the Turkish Competition Law Authority too. They are pretty open about it after reviewing everything. If they don't see any issue or they're satisfied with the explanations you've provided, they will leave it at that and they will share it at least informally. The Portuguese Competition Law Authority was kind enough to send it officially in a piece of paper. And you may say, well, what does it matter? I mean, if you don't hear back from them, be it, right? Better. Well, from an in-house perspective, it really matters. When you have to deal with auditors, especially if your company is present, it's a publicly owned company, it trades with, in stock. I mean, you need to provide, there's internal auditors, external auditors, there's the SEC, I mean, there's different regulators where you need to provide careful, consideration and careful information about these potential cases, right? So it makes our lives a little bit. I understand it's as a power, it's awesome to say, well, I don't know, I'll leave it open there. Maybe I pick it up in a few years later. But as an in-house counsel, it's the legal uncertainty. It's unnecessary in my view. How am I doing in terms of time? 4 minutes. Okay. Wow. All right. In terms of, let's say, increasing powers, this is something that I've seen in other jurisdictions. The guidance that, especially at the EU level, the guidance provided, it's really taken into consideration in other jurisdictions outside the European Union. And it is, as an in-house counsel, especially based in Europe, it's really helpful. Because it kind of sort of complements with the sometimes the lack of guidance or the lack of guidelines in other countries, in other jurisdictions. It's also it's a little bit, it can be a little bit dangerous in the sense that it's soft law. In theory, it should only oblige the authority that issued such guidelines. And there may be also, some arrogance if you try to say, but, Europe is saying this, so you should probably do the same. Right, you have to be mindful that you're outside Europe and you're outside, let's say, the jurisdiction. But it's definitely a power that is being picked up by other authorities around the world. I heard this morning, predictability versus efficiency. As an in-house counsel, I will always pick predictability, especially when you try to explain it to your clients. As a good example of bureaucracy, sometimes in certain jurisdictions there can be a clash of authorities over the same matter. For instance, when we're talking about mergers. HP has experienced this. I can talk about it because it's public information. We had a case in Mexico. I don't know if there's someone from COFECE here. I don't want to step on their toes. Okay, so basically we were notified an acquisition, and there was a fight over a year on which authority was supposed to take on the case and decide. So after a year, we were still, we were trying to close the operation and move ahead, and it really came to the point where we took the decision as a company to, well, let's do it, let's inform them for the sake of being a good player, and let's pay the fine. So we had to pay a $3.1 million US dollar fine just to close a deal. And in my view, it's kind of like the best example in terms of bureaucracy that I can think of. Last but not least, I wanted to touch base on legal privilege, which in my view is, as an in-house counsel, it's one of those topics that it's very close to my heart. The increasing powers, I can think of the Spanish authority, for instance, who, despite of the fact that the legal privilege is recognized in Spanish law, it's codified in Spanish law, that's very recent, even when acting under Spanish competition law, so no European competition law, they still consider the infamous AXO judgment still applicable, which, you know, it's a very good example of abuse of power, almost, in my view, but definitely increased power. And this view also that I think it's kind of old, of the in-house counsel as a sort of facilitator, you know, snibbling around, just trying to you know, do the mandate of our clients, which is really not true. It's I don't know if there was ever a time when that actually happened, but definitely I don't see that today. We are the first ones that need to explain competition law to our clients. All of you share this burden. The fact that we're still considered not being independent, I want to know of, you know, in terms of law firms, you know, the dependency when we're talking about millions of euros. I'd like to know, especially if you have a big client that is 50% of the revenue of your law firm. I want to know how independent you feel about it. Because I'm pretty sure, you know, that's and actually to, you know, bring in more into the legal framework, the debate is changing a lot. So now there's a majority of countries in the European Economic Area that recognizes some sort of, I wouldn't say that all of them are equal, but some sort of legal privilege to in-house counsels, okay? So before there was the idea, and an Advocate General Cod made this in written, that, well, there's only like 6-7 countries. I mean, it's kind of like these freakish countries, you know, that recognize legal privilege. But I mean, let's face it, most of the countries doesn't recognize it. Well, you know, this has changed, and it will continue to change. There's talks in France. I don't know then how the impact will be with elections and the formation of the new government, but there were talks definitely about getting the legal privilege codified in law in France. There's in the UK, there's in the Netherlands. I mean, I understand Italy is quite an exception, and hope that you can raise some awareness and some noise about this. Because it's in my view, we will only be able to do our work and to really, let's say, do our homework as legal counsels when it comes to competition law, when we are recognize the fact that our communications are privileged. And I'm going to put a stop here and let you go ahead with your list.
Thank you. Thank you for the invitation. It's really a pleasure to be here in Rome. I work at Delivery Hero. Perhaps a few words about Delivery Hero, because not everyone knows probably about it. We are.
You probably used it.
Yeah. Yes. So we are a holding company, and we hold a number of food delivery brands. One of them you probably know is Glovo, active in Italy, but also in Spain and many other countries in Europe. Foodora also, rather in the Nordics, Eastern Europe. We also have brands in APAC. We have Foodpanda over there. We have in Korea, Wuba. In Latam, we have Pedidos Ya. We have Hunger Station in Mina, and also Talabat. So we are really active all over the world. And obviously we also face a lot of antitrust issues all over the world, not only by the European Commission, as most of you probably know, that we were done already twice in the last 2 years, but also in many other countries. Perhaps to reaction on two of the topics you mentioned. On RFIs, I want to bring the angle of M&A, because I think it's extremely sensitive and extremely important, and I think it's something that authorities really are not taking into account. When you send an RFI, obviously we want to cooperate, and we do cooperate. We also have obligation under the SPA that we sign, so we need to follow certain process. So if you contact the managing director of a country and not the people that we have told the authority that they should be contacted, like the legal team or our external counsel, that facilitates a violation of the SPA if the managing director, for example, replies directly to the authority without involving the other party. And so that's extremely important. That can lead to, we always talk, okay, but what could be the consequence? We talk about fines in public enforcement, but you would be surprised of the fines that we can face under the SPA. It's usually much, much higher than fines you can face by public enforcement. It can potentially lead to the failure of the transaction. It's a default of our obligation, so it is extremely important. It's something that we see the counterparties being more vigilant. We are also being more vigilant because we all know major control filings and also FDI filings are getting more complex, are getting more difficult. So we want to have visibility and control over everything that is happening between, let's say, the seller and the authority. We want to be informed, we want to have the possibility to comment, and that's why it's really important that authorities try to cooperate also and be more understanding of the sensibility, which I also believe doesn't really impact the ability to review the merger, which is ultimately and I know that they don't have the intention to make any harm. It's probably something that's just not on their radar, and probably used to doing that and keep doing that, but it is extremely important actually. Second reaction, it's about public listed company having the obligation to report ongoing investigation. So now we have had many investigations dormant. We call them dormant investigation. When they are for more than 2 years, we have had any interaction with the authority. The tricky part is indeed discussion with auditors, right? They come to you and they, okay, what about this investigation you had in Bahrain or Chile or Brazil or whatever? And then you tell them, well, we haven't heard from them in 2 years. Then you need to make an assessment, okay, fine, but are you gonna hear from them? That's the tricky part. You actually don't know. Just maybe try to contact the case team. The case team is not there anymore. We have had an investigation with the Chilean authority for 4 years. The case team changed every 3-4 months. I think we have had 6 different case managers. So again, I understand this is not an intention to make any harm to the company, but it would be really, really helpful to know when a case is not a priority anymore. Let's call it that way. Maybe you don't want to close it, because I can also understand you want to have the possibility to reopen. But it would be good to just receive an email and say, look, I mean, we are not actively investigating this anymore, without the possibility that we have to continue at some other point. But for now, it's all we had. Some authorities do that. Some others, the majority, don't do that. So these are 2 reactions. I also want to bring a topic that I think it's lead to an increased power of authority, or that I hope acts as a balance on authorities having more power, which is, first of all, having more clear rules. We proactively, on our own initiative, but also at the request of many authorities, mainly in MENA region, I have to say, MENA authorities do reach out to our local teams to have their comments on many legislative initiatives, which is very welcome. Sometimes they don't hear us. I mean, they note our comments, but they don't agree, which also is fine. We are, for example, now interacting a lot in Turkey with the new amendment of the, let's say, Turkish version of the DMA, which includes both quantitative and qualitative criteria. So we are trying to convince the authorities that qualitative criteria go against predictability and legal certainty, because again, we actually can't know if we are gatekeepers or not. Based on quantitative criteria, maybe we are not, but who knows if based on qualitative criteria, the authority considers that we are actually gatekeeper, and we don't know. So having more clear rules, I think that would be perhaps more guidelines. You mentioned that. I like that. The idea of
the power of guidelines.
Yeah, of authorities having, I mean, Commission certainly and European authorities have a lot of guidelines, but I don't know how many of you wonder how many guidelines authorities in MENA, in Latin and Asia have. There are some very serious and solid authorities, but it is very frequent the case that we have no guidelines. Also frequently the case in the last year that there is no authority in theory, but there is antitrust enforcement by ministries. We have a case last year in Bahrain, for example. It's the second time I mentioned Bahrain. That was not in my notes, but yeah. So we do see that, which I guess is also a way of entering into the wall of antitrust enforcement. I'm too young to comment, but I think also in many European countries that's how enforcement of antitrust started, at government ministerial level. Second point is due process. That's probably the key point I want to make. And we have faced really lack of due process in many countries. For example, we had a merger in Central America, some very good interaction with many authorities, but some others we submitted a filing. The External Council told us that we would get around 6, 7, 8 RFIs, and then eventually maybe remedies discussion with the authorities, maybe 1 year, 2 years. The time passed, no RFI at all. Few months, 1 RFI on revenues. After a year, we get a merger decision imposing remedies. So this really, of course, they have the power to do so, but I don't think it's a healthy public enforcement of competition. I think that leads to not fact-based merger decisions. And obviously the remedies they impose, I mean, very aggressive remedies, hold separate for 6 years with the ability to extension maybe for 3 years more. So is that really a clearance? Not sure. So it would be good to encourage really authorities to be more developed in the sense of interacting and respecting their own process. This is a process they have set out in guidelines, but maybe they don't really follow in practice. We have had very good experiences, I have to say also. We negotiated commitments in a vertical antitrust investigation last year in Chile and Hong Kong. Very similar investigation is public on price parity and exclusivities. So we have had a lot of interaction with the authority. We have had the ability to discuss on every clause of the decision or every paragraph of the decision that they were pursuing to publish. That was welcome. That's also why I believe the investigation ended up in a commitment. When the authorities try to impose us certain commitment and they ask us to either accept or not, usually we don't accept. But in Chile and Hong Kong, we managed to, we ended up with commitments. There are a few points, right, like important. I think commitments cannot be forever. And I think this is something that the Hong Kong and Chilean authority really took into account, and we accepted commitments. Again, it's public, but for 2 or 3 years on removing certain clauses. And also, I think a very important clause is a review clause of the commitments. Obviously, we can understand that the authority doesn't want to review the commitments, but in a market like food delivery, things change very, very rapidly. I know this is something, because I have been in law firms before, this is something that we always said, regardless of the client. But really, food delivery, things can change very quickly. I was discussing with someone, I can't see him now, but he was telling me, oh yeah, there is this food delivery platform in Hungary. That platform is not in Hungary anymore. It's another one. It's Foodora now, for example. We have seen, again, following up on the example of Hong Kong, which we told the authority. They were very reluctant to hear about that, but we told them that Meituan was planning to enter Hong Kong. They were reluctant to even agree that Meituan would enter, even though Meituan said publicly that they would. But we also told them that it's not only about entering, it's also about how quickly you can reach a very significant market share in Hong Kong in a very short time. We have a lot of experience, and we know for facts that in 2 months you can reach a market share of at least 15 or 20%. I know this is very surprising for many industry, but in food delivery, if you have financial support, and Meituan obviously have a lot of financial support, it is very possible. Again, the authority was reluctant. A lot of discussions, 2 months, 3 months of discussion, which gave us enough time to actually prove that what we were saying actually happened. Because in 2 months, Meituan had around 15 or 20% market share. But again, very glad that we could have this open discussion, even though we didn't agree initially, probably also not at the end, but we, as part of the commitment, you need to reach a middle point at some point, and I think we're relatively happy with the outcome. And then the last point is judicial review. So more clear rules, due process, and last point, judicial review. I think these are the 3 main elements that would balance an increase of powers by competition authority. I will keep it very short, but we have seen countries where you disagree with a merger decision or with an antitrust decision, you ask external counsel, can we challenge the decision? And the answer is, yes, you can, but you will get a very short judgment saying that what the authority has concluded is proportionate, and that's it. So we were reluctant to believe lawyers. Sometimes we are, but they were right, as they usually are. And we got 2 pages, I think, judgment, first instance, saying exactly that, not fine. The decision is proportionate. Then we asked, can we appeal? First instance, and the answer was again, yes, you can. But in the last 5 years, we haven't seen any appeal judgment. So they just stand there forever. Time passes and you get no answer. Silence doesn't go in your favor. So while it is pending somewhere in the court, you can't do anything. So not really helpful. I was attending a panel before where the Croatian president of the Croatian authority said that they are trying to train judges and they are refusing to do so. Very interesting, because I wanted to make the point that judges should be more trained, but I didn't expect that. in many countries, judges actually don't want to be trained. And maybe I will stop here. I think I've talked really a lot.
Yes, sorry. I didn't want to interrupt you. It was very interesting. Thank you for both sharing your views so transparently, for bringing us so widely around the globe. There are many topics you touched I would like to comment on, but running short out of time, maybe I will focus just on a couple of them. And first, I just wanted to bring you back in Europe, in Italy, with the good news. We have deadlines for national investigations, so this is something that maybe can be taken as a model from the Italian Competition Authority. And I would like to come back to the fil rouge, let's say, of many comments you made, that is predictability. We need predictability, and we need that also with respect to the new powers that we are seeing many authorities are now acquiring. And I would just like to focus on sector inquiries and merger below thresholds. So sector inquiries have already been mentioned. You touched upon a very sensitive issue. They are too broad often. But if you have done your homework, if your compliance is fine, you know you are not scared about it. Okay, it can be very burdensome, but yes, it can lead to some investigations, but you have nothing to be worried about. What I believe now we should be worried about is that many competition authorities now can open sector inquiries and are also entitled to apply remedies that can be behavioral or structural. And these remedies can be applied even if there is no evidence of antitrust infringements, and if just vague competitive problems arises. And why I'm so worried about it? Because we know the UK already has this system since a while. The German Competition Authority was also given the same powers recently. The Italian Competition Authority was also given these powers more recently. And the Draghi report now is somehow revamping the new competition tool that the European Commission wanted to adopt in 2020, and then it abandoned this project following a public consultation. So we might expect that the new Commission will like to come back on that. And what I wanted to share is some worrisome aspect of our Italian model, just because I wouldn't like to see the same problems in the EU model. What am I referring to? You have heard this morning these remedies can be imposed because of a legislative novel that was initially thought only for the air transport sector, and then it was widened to other sectors, but just through an interpretative opinion of the Council of State, which is quite dangerous. I mean, this instrument probably lacks a real solid legal basis in other sectors. But this is a problem that eventually will arise in those sectors when somebody will be appealing possible remedies. But there are more worrisome aspects that I would bring you to. The first one is that you are not able, as an in-house counsel, to be supportive to your company, to your internal client, in anticipating whether your sector could be subject to a sector inquiry. You are not able to say which kind of remedies could be imposed. You are not able to figure out how the competitive concerns could be addressed, and if there are remedies that you might wish to offer the competition authority. And why this? Simply because neither the law nor the communication from the competition authority clarify what are the circumstances that shall be taken into account to establish the existence of a competitive problem. So what is a competitive problem? We don't know. We are not able to anticipate that. Same problem arises when we read through the communication setting out the procedural rules of the competition authorities. And in that communication, the authority says that it can impose remedies if it identifies competitive problems that are suitable of distorting or hindering competition. So, irrespective of whether they do, in fact, distort or hinder competition, it's enough that they are suitable to do that for there be a need to address that and to impose remedies. And this is, again, something that you cannot anticipate in any way. So, talking about predictability, legal certainty, I feel in a very uncomfortable situation there. And then a final aspect, a critical aspect that we are facing is that these powers can be exerted even in regulated markets. So, as a company, you have not infringed competition law, you have abide by all regulations, and still you might be facing behavioral or structural remedies that are in fact the exercise of a regulatory power. So there is probably an overlap that has to be mitigated there, and this is probably the very reason why we have seen the Italian energy regulator appealing against the communication of the Italian Competition Authority before the administrative court. We don't already have the judgment on that, but there might be so at a certain point in time an intervention by judges that could either confirm this broad interpretation of the powers of the competition authority or somehow restrict it. So to conclude on that, what is for sure the situation we are facing is a great uncertainty. You are not able to predict whether you will be involved in such kind of sector inquiries, and just we hope that this model will not be replicated somehow at the EU level. And again, on predictability, the other main topic that I would like to touch upon is merger below thresholds. Why this? We all know beginning of this month we had the Court of Justice judgment in the Illumina Grail case. We, I think, were all relieved by reading both the court judgment and before Advocate General Emilio saying that the main problem was the need to ensure legal certainty. So now we have a judgment. Is this the happy hand? No, I'm afraid not. Why this? Because of the very first reactions that we heard from the European Commission vis-à-vis how to address now killer acquisitions. Killer acquisitions are still there. It's a problem that the European Commission need to address. Fine. What are the solutions? So, Commissioner Vestager indicated what are the main possible solutions that they are envisaging. Two solutions were clearly indicated as something they do not will to pursue, and they were lowering thresholds so that more acquisitions could be examined. The other solution was adding a value threshold, and this again would add a burden on companies because of increasing number of mergers to be notified. So apparently this is not where they want to go. Another possible solution that was mentioned was to add call-in power to the Commission powers. But this, Vestager very transparently said, would appear to be against the spirit of the judgment, because it is true, it would be in the regulation more clearly, so maybe an amendment to Article 22. It would have a solid legal basis at that point, but it would be against the spirit of the judgment, meaning that a call-in power means you don't have legal certainty. So what was in the end the envisaged solution they appear to be working on? I'm quoting here, and it was the encouragement to member states to expand their jurisdictions. And to give an example of that, Mrs. Vestager mentioned 8 member states, including Italy. So what did Italy do? Italy did simply introduce a merger below thresholds regime. So this is what Vestager is thinking about. More national below thresholds regime. But in my view, this is simply shifting the problem of legal certainty from the EU level to the national level, or to the national levels, so that we will face legal uncertainty in multiple jurisdictions, and then in the end, the idea would be that if the Commission sees a merger it wants to intervene on, it will ask national authorities to bring it to her through the proper interpretation of Article 22. But so we should be worrying about a wide number of below merger thresholds regimes. So the only thing that we are facing now for sure is that as in-house lawyers, when we look to M&A deals, we know that we should not anymore care about possible merger filing obligations, but even if we are dealing with a very small deal in just one country, so with a very limited business activity, we should still also have an impact assessment of this deal, looking at the substance of the deal, to wonder whether this might attract a call-in power by the national competition authority. So, less legal certainty, more burdens on companies. I think we have very few available time. I think we are all overlapping with another session, so maybe I'll stop here and just leave the floor to interactions if there are counter-arguments. Okay, there is not.
Hello, this is Christoph Raab from Binder Grösswang in Vienna, so an outside lawyer interrupting the in-house lawyers. I was just reflecting on... Don't worry. I was just reflecting on your last point, because you said that there's more uncertainty through the increased powers of the competition authorities for ex-ante review. But I was thinking about whether an ex-ante review is not something to be somehow welcomed because of the new possibilities after the tower cast judgment. So at least you get, you know, the certainty when you finally close the deal, if it's reviewed by the Commission, at least it's not ex post reviewed under the tower cast judgment.
Yes, so thank you for reminding us that we also have the tower cast problem.
Sorry.
It is true, but you still would like to have more predictability. And there was one aspect of the Italian below threshold regime that I initially considered to be something I would not go through, that is the voluntary notification. But maybe in the end this is not so bad. I mean, the reason why I was saying that I would somehow don't want to go through that is that the Italian regime foresees that if you want to make a voluntary notification, you should also explain the competition authority why you believe there is a competitive concern in your deal, which is exactly the opposite that you are supposed to do. I mean, that you usually do when presenting a merger. You are trying to convince the authority that there is no issue. But the way the communication is written, there are some requisites that you have to fill in, and one of them is explaining why you believe that the merger you are presenting raises some competitive concern. I don't know whether you want to intervene too?
No, I mean, more practically speaking, I think ex ante, I wouldn't say it's welcome in the sense that you need to, if there is going to be a file, you need to know whether something is notifiable or not. And the problem is that you don't really know if it is notifiable, right? So then how do you reflect that in the transaction documents? How do you incorporate in the condition precedents that you have in the SPA? How do you structure the long stop date? How do you structure the extension of the long stop date? So there's a number of questions arising from the fact that you don't have visibility on whether something is notifiable or not. It's not that we want to avoid filings. We want to make the filings that we have to make, but we don't want to not know.
Hello, my name is Teresa, and I am neither an in-house counsel nor an outside counsel. I'm an academic, so I'm doing a PhD, and I was wondering if and I want to ask you about something a bit different from the problems that you've raised, but that nonetheless I was wondering if it was relevant. Have you had any problems with competition authorities with any of the, like, if you wanted in the past or now to do a sustainability initiative jointly or on your own, and has it been a problem? Have competition authorities ever posed a problem to you because of this initiative, or have you stopped the initiative because you were worried about how competition authorities would react?
But in terms of collaboration with competitors?
It's mostly collaboration. Yeah, I'm thinking mainly collaborations, but also maybe how you choose your suppliers in case you have been at any point found dominant. I was wondering if it's a problem.
On my end, no. Thanks, God.
Problem for you.
Don't want to give any ideas. We're good as we are. How about you?
No, the only problem is that we still feel we miss clear guidance. I mean that the European Commission, many other authorities intervened in this field. The European Commission didn't say a lot, let me say. I mean, there are a large number of pages now in the horizontal guidelines, but it's still difficult to understand which will be the right balance between the different interests that are on one hand competition and on the other hand the sustainability goals. There have been other authorities like the French one which didn't really give any added value. I mean, they just said we are open to discussion, please come, we maybe will give an answer. The Italian Competition Authority, so far we heard this after lunch, is still not adopting any guidance. They're more focused on achieving sustainability through the application of competition law, which is also a part of the deal. But so we don't have clear guidance on how far we can go. So no, I wouldn't say we had any problem, but we had doubts. I mean, and when you have doubts, you act more conservative. So maybe we could have gone a bit more in our cooperation, but we stopped earlier. That's it.
Question over there? No? It's just the sun? All right. Okay. Yeah. How about the audience is cooking?
I want to say something I mean, sustainability cooperation. We have done some initiatives when it comes to e-mobility. But I mean, basically, it's all run independently by every player. The only cooperation we have done is when it comes to submissions for legislative proposals. And very openly, everything is public. But I can agree that at some point, for some details of e-mobility plans, we could have gone further, but there were doubts, so we didn't. And another angle that I'm not actively involved, but I know it's very important for Delivery Hero, is the Supply Chain Act that we have to, obviously, as a German public listed company, we have to comply with. And it is an important topic when it comes to riders, for example, in many countries, human rights. So I know the compliance team is heavily involved in this, and it is a very important topic at Delivery Hero.
Yes, I think that's all. So thank you for your attention. And just wanted to be more precise in what I said before, and to give you a clear example. When I said we stopped a bit earlier, it was I was thinking about a situation where in an association dealing with, you know, these obligations on the due diligence, reportability directive, and so on. So it was about whether we could discuss in the associations and define a standard for our reporting obligations. And this is something that is even foreseen in the directive, which recommends companies to cooperate to define a standard, because otherwise we have these due diligence reporting obligations, but if each company is reporting its activity in a different way, probably the directive will not meet its objective. So the European legislator was encouraging companies to somehow define a common standard. But still, there were companies that were more cautious and didn't want to go that path. So let's not discuss this. And of course, you need to respect these willings. I had the feeling we could have done more, still being compliant with competition law rules, but the project was just abandoned. And I think it's maybe a pity, because the aim was noble somehow and was supported by the legislation. That's it. So again, thank you all.